We're ready. Good morning. This public hearing is now called to order. Today is Friday, July 24, 2015, and the time is 10:09 a.m. This is a public hearing on a resolution to repeal and reenact Section 8150 of Article 81 of the New York City Health Code. I am Harminder Pal Rana, Assistant General Counsel for the New York City Department of Health and Mental Hygiene. And also here today are Megan Lent from the Bureau of Chronic Disease Prevention and Tobacco Control, and Michelle Robinson from the department's Bureau of Food Safety and Community Sanitation. And here with us also and assisting us quite ably is Svetlana Burdanik, Assistant to the Secretary to the Board of Health. The purpose of today's hearing is to elicit public comments and information to assist the Board of Health in determining whether to adopt this proposal. A notice of intention and notice of public hearing regarding this proposal was published in the City Record on June 23, 2015. A copy of the first page of the notice of intention has been provided to the reporter and to include in the record. Speakers are generally limited to 5 minutes. Persons wishing to speak at this public hearing were asked to pre-register. 3 speakers were pre-registered to speak today. The first speaker is Joseph Masher of the National Association of Theater Owners of New York State. Mr. Masher, please. Thank you.
Good morning. My name is Joe Masher. I'm the president of the National Association of Theater Owners of New York State, which is a not-for-profit trade organization representing movie theaters across New York State. In New York City in particular, we represent 37 theaters, 312 screens, and roughly 1,800 employees across the 5 boroughs. We're here today to oppose the menu labeling requirements. If the desire is for New York City's requirements to be in line with the federal requirements, then we believe that the Board of Health is premature. The federal requirements were originally supposed to take place, as you know, on December 1st of this year. However, the FDA recently announced that they are delaying the requirements for a full year until December 1st of 2016. Accordingly, if New York City is to follow suit, this hearing should be taking place next July and not today. After all, New York City already has menu labeling at a significant cost to the business community. Why would the city ask its food service establishments to make changes now and possibly again in just a year? There are several issues that the FDA will decide during the course of this 1-year delay. One of those issues includes how caloric information will be posted for multiple serving items, such as a bottle of wine, a full pizza pie, or even a bucket of popcorn. Should that be by the glass, by the slice, divided in half? We don't know yet. It's to be determined. The same is true of the standard menu items that come in different flavors, varieties, or combinations that are listed as a single menu item. These would include soft drinks that may be dispensed by Coca-Cola's new Freestyle or Pepsi's new Spire machines, as well as ice creams and desserts like donuts. Determining the caloric amounts for those items can be done through ranges, averages, or other methods as determined by the FDA, and that determination has not yet happened. And it won't happen for at least another year. So why would we rush to change New York City's menu labeling regulations and again impose costs on businesses until we're certain what the federal regulations will require? Accordingly, instead of listing December 1st, 2015 as the effective date for these New York City regulations, there should instead be language stating that these regulations will become effective only until the federal regulations become effective without stating a specific date. This way, if the federal regulations are further delayed, New York City food service establishments will not have to rush to comply with new New York City regulations and then very likely have to make other changes once the federal regulations take effect. So we respectfully urge that the Board of Health take these points into consideration before passing this amendment to the Health Code. Thank you very much.
Thank you, Mr. Masher. The next registered speaker is Jay Peltz of the Food Industry Alliance of New York State. He is Vice President, Public Affairs, and General Counsel. Mr. Peltz.
Thank you. I think you have a copy of my submitted testimony that I emailed yesterday, in case you don't.
Yes, you can.
I'm going to read some of the versions.
That's fine. Thank you.
Just to make sure. morning. Thank you for the opportunity to testify at today's public hearing. My name is Jake Peltz, and I'm General Counsel and Vice President of Government Relations for the Food Industry Alliance of New York. FIA is a nonprofit trade association that promotes the interest statewide of New York's grocery stores, drugstores, and convenience stores. Our members include chain and independent food retailers that account for a significant share of New York City's retail food market and the grocery wholesalers that supply them, as well as many of New York's drug and convenience stores. I will now read a summary of my submitted testimony. Under the proposed calorie posting rule, a covered establishment is defined as, quote, a food service establishment or similar retail food establishment that is part of a chain with 15 or more locations nationally. Similar retail food establishment is defined as, quote, a food service establishment such as a convenience store, grocery, or supermarket that serves restaurant-type food. Food service establishment is not defined in the proposed rule. That term, however, is defined identically in section 81.03 of the NYC Health Code and section 23-01 of chapter 23 and title 24 of the rules of NYC. A food service establishment is, quote, a place where food is provided for individual portion service directly to the consumer, whether such food is provided free of charge or sold, and whether consumption occurs on or off the premises. Indeed, this is the definition of food service establishment used in the current calorie posting rule, and that phrase, individual portion service, is key. That's in the state definition, city definition. That's what typically carves out grocery stores and convenience stores. Licensed food processing establishments, including thousands of grocery, supermarket, and convenience stores operating in New York City, about 5,000, do not meet the definition of, quote, food service establishment under the NYC Health Code or section 2301 of the NYC rules, nor are they food service establishments under the state sanitary code, the current calorie posting rule, the original 2006 calorie posting rule, the sodium warning rule proposed simultaneously with this rule, or the memorandum of understanding between the State Department of Agriculture and the State Department of Health, which binds this department. To the contrary, these businesses meet the definition of, quote, food processing establishment under section 251C2 of the State Ag and Markets Law. As a result, these establishments have been permitted, regulated, and inspected by the State Department of Agriculture with regard to food operations. Accordingly, we respectfully request that the proposed rule be revised so that grocery, supermarket, and convenience stores that are licensed by the State Department of Agriculture as food processing establishments are expressly excluded as covered establishments under the proposed rule. The fact that food processing establishments are permitted by the State Department of Agriculture is particularly important. On page 25 of the department's reply brief submitted to support its appeal of the lower court ruling invalidating the soda ban, this department declared, quote, the portion cap rule applies to all food service establishments regulated and permitted by the department. This is consistent with all of the requirements of Article 81 of the Health Code. Since food processing establishments licensed by the State Department of Agriculture are neither regulated nor permitted by the department, such businesses should be removed as covered establishments under the proposed rule. To include them would be inconsistent with all the requirements of Article 81 of the Health Code. Moreover, the attempt to regulate and inspect licensed food processors as food service establishments directly conflicts with decades-old state policy as reflected in the MOU. The department apparently believes that the MOU does not apply to the proposed calorie posting rule since it is, quote, a labeling rule. However, titles of rules do not resolve jurisdictional issues, the substance of them does. Accordingly, while the soda ban was titled the, quote, portion cap rule, and the FDA and the department referred to the calorie posting rule differently, in the end, the soda ban and the calorie posting rule are about the same thing, changing behavior through regulation with the overall goal of improving the health of the general population by reducing calorie consumption. The MOU, originally executed in December of '85, provides that, quote, agriculture will be responsible for the inspection and regulation of places where food is processed or manufactured, food warehouses, wholesale food distributors, and retail food stores. The department expressly acknowledged the State Department of Agriculture's jurisdiction over grocery stores and 7-Eleven on pages 16 and 27 of its reply brief in the soda ban case. The department, however, has concluded, without any coordination with or analysis from the State Department of Agriculture, that thousands of food processing establishments, about 5,000, operating in New York City, licensed, regulated, and inspected by the State Department of Agriculture, are also food service establishments for purposes of the calorie posting rule. What then? The department itself provided the answer on page 26 of its reply brief. In quoting from the MOU, the department noted, quote, if an establishment has operations that may fall under the jurisdiction of both health and agriculture, AD shall have jurisdiction over all operations of the establishment, unless sales of food for consumption on the premises or ready to eat for off-premises consumption measured by annual dollar receipts, exceeds 50% of total annual dollar receipts, in which event health shall have jurisdiction of the establishment. So it's a 50% test, store by store. The department further amplifies its position on page 27 of its reply brief. Quote, thus, under the MOU, the departments will meet to determine whether a particular establishment is being regulated by the correct department based on its sales receipts. Furthermore, the lower and appellate courts in the soda ban case were clear that when there is uncertainty regarding jurisdiction, the two agencies must meet to resolve the issue. To our knowledge, no such cooperation between the State Department of Ag and this department has occurred to date. Finally, the MOU provides that, quote, in no instance shall an establishment be required to have a license or permit to operate from both departments or be inspected by both departments. Thus, the designation of the Department of Consumer Affairs as an enforcement agency under the proposed rule thwarts a clearly articulated purpose of the MOU to prohibit inspections by or through a local health department once a determination is made that an establishment is a food processor. Lastly, what legal authority does the department have to empower another agency to enforce one of its rules? In light of the foregoing, we respectfully request that the proposed rule be revised so that grocery, supermarket, and convenience stores that are licensed by the State Department of Agriculture as food processing establishments are expressly excluded as, quote, covered establishments. The department's desire, asserted in the statement of basis and purpose of proposed rule, to, quote, repeal and reenact Health Code Section 81.50 so that its requirements are identical to the federal requirements, does not override the requirements of the MOU, nor does it override the decades-long practice of not regulating licensed food processors as food service establishments under the State Sanitary Code, the NYC Health Code, or Section 2301 of the NYC rules. It also conflicts with the current calorie posting rule and the original 2006 calorie posting rule, neither of which covered licensed food processing establishments, as well as the proposed sodium warning rule. In any event, the proposed rule is not identical to the federal rule. It seeks to continue to cover, quote, chains with 15 to 19 locations nationally, while the federal rule defines a chain as a business with 20 or more locations nationally. Thank you very much for your time and attention to FIA's concerns. I'd be happy to answer the questions if I have.
Thank you, Mr. Peltz. This is essentially a one-way public hearing where you get to tell us everything and we don't get to.
The council committee meetings are different. Those can be very much interactive.
Right.
Thank you.
Thank you.
You're welcome.
The next registered speaker is Robin Vitale. I apologize if I'm pronouncing your name correctly, of the American Heart Association.
You're quite close, it's Robin Vitale, but I'll take any that derivation of that. So I'm thrilled to be invited here to provide some supportive testimony on behalf of the American Heart Association, American Stroke Association. And as the previous testifiers seem to not be debating the merits of menu labeling, I'm able to synopsize tremendously and skip through some of the data that I was going to present that would justify why menu labeling is so warranted and so warmly received in the city and several other jurisdictions. Essentially, we're here because we know that Americans now are consuming nearly half of their food budget on meals consumed outside the home. And foods eaten away from home are typically served in larger portion sizes and usually have more calories than those that are prepared in the home. And so research documents that this obviously has a direct corollary to obesity, and additionally consumers have also been unable to accurately gauge calorie counts for their meals, often believing that calorie levels are significantly lower than in reality. For all of these reasons, both empowering the individual as a health-conscious consumer as well as promoting industry change in restaurants, we've been very supportive of menu labeling initiatives since 2006, when this body really led the country in discussing the merits of this proposal. And the results have been very strong. 86% of consumers thought that New York City's initiative was very positive. 84% said they read the calories on menus. 97% said that calories were higher than they expected, and 77% said that restaurants have a responsibility to respond to consumers' nutritional concerns. So with all of the comments that were just offered a moment ago, I want to skip a little bit forward to talking specifically about the ease of implementation of this requirement. Standardizing calorie information on menus is easier for larger fast food chains where food preparation and portion sizes are highly controlled. However, accurate nutrient composition databases and software for labeling are widely available, and it's easier than ever before for all restaurants to calculate calorie content in menu offerings. No matter which restaurant consumers choose, they need and deserve the calorie and nutrition information. The ability of customers to customize ingredients in some of their meal selections does pose a challenge. However, for most food items, a close estimate of calories will provide consumers the information they need to make an informed and healthy choice. American Heart Association continues to advocate for swift, strong implementation of the federal regulations. Ultimately, it would be in the best interest of public health to have calorie labeling mandated in all food service establishments. Restaurants not covered by the federal law remain subject to any state and local regulations, and the association will work to ensure that restaurants with fewer than 20 locations adopt menu labeling as well. As the New York City law currently impacts restaurants with 15 or more locations, the AHA therefore strongly supports the extension of the federal rules to food service establishments that maintain 15 to 19 locations nationally. By mirroring the federal regulations for all restaurants with 15 or more locations, New York City can be a true partner with our federal leaders to better support restaurants and ensure compliance in advance of the national standard. A healthy diet is essential to sound cardiovascular health, and this legislation should help consumers to do a better job managing their weight, thereby reducing their risk factors for chronic disease. So again, on behalf of the AHA and American Stroke Association, thank you for your attention and consideration of our support for this proposed update to Amendment 81. Thank you.
Thank you, Ms. Vitale.
Thank you.
I am not aware of any other registered speakers at this time. If someone wishes to register to speak, they are free to do so. Since there are no registered speakers at the moment, I am going to adjourn this hearing until approximately 11:55. And if there are individuals who appear in the interim who would like to speak, we will be notified, and we may reconvene at that time. Thank you. This public hearing is adjourned until that time. Thank you. Mr. Robinson. Good afternoon. This is the resumed public hearing on a proposal by the Department of Health to the Board of Health to repeal and reenact Health Code Section 81.50. The time is now 12:01. We have not been made aware of any additional speakers who wish to speak at this public hearing. Accordingly, since the time has elapsed for this public hearing, I am now concluding it. And the public hearing is now concluded. Harminder Paul Singh Rana, Assistant General Counsel, and with me are Michelle Robinson, Director of Food Safety, and Ms. Megan Lent, a Policy Analyst for the Department's Bureau of Chronic Disease Prevention and Tobacco Control. And we collectively now conclude this hearing. Thank you.